Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about how is maritime law enforced in the UAE. The commercial maritime law in the United Arab Emirates is regulated and enforced by Federal Law Number 26 of 1981 or Maritime Code. A brief snapshot of some key features of the Maritime Code are set out below, which have implication for maritime trade and commerce. Registration of the vessel having a UAE nationally are required to be registered with the Maritime Inspection Department under Article 18. There are expectations to this requirement with fishing boats, pleasure boats, or boats used in commerce, having tonnage less than 10 tons, not required to register with the authority. Operating a vessel which files the UAE flag but is not registered under the Maritime Code is punishable with imprisonment of up to 1 year or fine of up to AED 50,000 or both. The vessel may also be confiscated under Article 44. Cargo contracts and losses. The Maritime Code regulates the contract of goods over maritime transport. Article 256 per 1 defines a contract of maritime transport as follows. A contract of maritime transport is a contract whereby the courier undertakes to carry goods from one port to another in consideration of freight that the shipper is obliged to pay. This contract is proved by a bill of lading, which must contain details of the courier, shipper, and consignee, the goods being shipped, port of the departure and arrival, name and nationality of the ship, freight charges and method of this calculation, place and date of issuance of the bill, number of copies and signatures of the captain and shippers. The carrier is liable for the losses or damages incurred to the goods and also from the time of receipt of goods till delivery or with exceptions set out under Article 275. That said, the liability of courier is limited to AED 10,000 for each package or AED 30 each kilogram of the weight of goods, whichever is higher, unless the parties have agreed on a higher limit of liability under Article 276 per 4 of Maritime Code. Collision of vessels default by one of the vessels leading to a collision would result in the defaulting vessels also compensation to non-defaulting vessel for the damage it is caused by under Article 330 of the Maritime Code. And then, however, Article 321 per 1 clarifies that in case that default is of more than one party, the liability of each vessel would be estimated based on the proportion of default of the defaulting vessels. Arrest of the vessels. A vessel could be arrested by an order of the civil court and having jurisdiction solely on the ground of satisfaction of the maritime debt. A maritime debt has been defined under Article 115 of the Maritime Code as a claim in respect of a right arising out of any of the following causes. The first RDA is damage caused by the vessel by reason of a collision or otherwise, and B, loss of life or personal injuries occasioned by the vessel and arising out of the use thereof, and C, assistance and salvage, and D, contracts relating to the use of exploitation of the vessel under a charter party or otherwise, and E, contracts relating to the carriage of goods under charter party, bill of lading, or other documents. And then the next, or the F, is loss of or damage to goods or chattels being carried on the board the vessel. And then the G is general average. The H is towage or pilotage of the vessel. And then the E, supplies of products or equipment necessary for the utilization or the maintenance of the vessels, in whichever place the supply is made. And the G is construction, repair or fitting out of the vessel, and cost of it being in dock. The K is sums expended by the master, shippers, charterers, or agents on the account of the vessel or on account of the owner thereof. And then the E, or the L, wages of the master, officers, and crew, and other persons working on board the vessel under a contract of a maritime employment. And then the M, a dispute as to the ownership of the vessel. And the N, a dispute in connection with the co-ownership of the vessel or with the possession or use thereof, or with the right to the profits arising out of the use thereof. The O, a maritime mortgage. The order of arrest can be set aside by the civil court if a guarantee or any other security, which is sufficient to satisfy the debt, is presented before the court under Article 118 Part 2 of a maritime code. That said, where the maritime debts related to the dispute as to ownership, co-ownership, possessions, or use or right to profits arising out of the use of the vessel, the order of arrest may not be set aside. An arrested vessel is forbidden to sail. And the conclusion is maritime jurisprudence is constantly evolving as the UAE grows into one of the biggest locations for maritime operations, and it is follows international best practices and standards for governing maritime matters. And this content is the article is intended to provide a general guide to the subject matter, and a specialist advice should be sought after about a specific circumstances. So thank you for watching, and don't forget to like, comment, and subscribe.